1837, the United States was interested in acquiring timberlands from the Ojibwe in parts of what is now Minnesota and Wisconsin. It was at that time all part of the territory of Wisconsin, I believe. This predates Wisconsin statehood and Minnesota statehood. And there was no real settlement in this area, stretching from the Mississippi on the west into Wisconsin on the east. But there was the beginning of timber harvesting, and in order to kind of control access to the timber rather than having individual timber operators negotiating with different bands and acquiring rights to timber, the U.S. decided to negotiate a treaty to acquire about 13 million acres of land. And the purpose of the treaty was not to really pave the way for settlement, but to allow for timber harvesting. During the treaty negotiations, which took place at Fort Snelling, Ojibwe spokespersons said they wanted the right to remain on the land and have access to fish, game, and other resources that they used to make their living. So a provision was included in the treaty which said that the privilege of hunting on the land, fishing in the rivers, and gathering the wild rice was guaranteed to the Indians during the pleasure of the president. In 1848, Wisconsin became a state, and that's when politics starts entering into this story in kind of a big way. The Ojibwe were receiving annuities, annual payments, under the 1837 and 1842 treaties, and I think under the 1847 treaties as well. And most of the Ojibwe parties to those treaties were in what would become the state of Wisconsin. And so the annuities, which were paid in cash and goods, were distributed in Wisconsin, in an island on Lake Superior. This was big business at the time. There wasn't a lot of cash on the frontier. There wasn't a lot of economic opportunity on the frontier. There were kind of some fur traders and others in Minnesota, which was we now have the Minnesota Territory, what's left over from the original Wisconsin Territory. And they're not getting access to any of the economic opportunities associated with the annuity payment. So they were interested in moving the annuities payments into Minnesota, and the only way to convince the government to do that was to move the Indians into Minnesota. So that started this push for a removal order to remove all the Wisconsin Ojibwe from Wisconsin into Minnesota, change the payment location from Lake Superior to Sandy Lake, and accrue the economic benefits of that. But that wasn't what they said publicly. What they said publicly is that the Indians were annoying the settlers and they had to be removed in order to protect the settlers. And the problem with that was that there weren't any settlers to speak of. Most of the Americans that were interacting with Indians were timber companies and miners who were hiring Indians to work in the mines, to cut down trees, or to supply the miners and the timbermen with food and other resources. And it was a little ironic for Minnesota to be claiming that the Indians were a source of annoyance to settlers, and at the same time they were asking for thousands of Indians to be moved into Minnesota. Mille Lacs, who was a party to the 1837 treaty, was not really a part of the removal effort. There was no effort to move people from Mille Lacs because the Minnesotans had no benefit to be gained from that. And in fact, there were efforts to move people from St. Croix to Mille Lacs. So if anything, during this removal effort, the population of Mille Lacs increased. There was a lot of resistance among the Wisconsin Ojibwe to removal. They didn't want to be moved to areas in northern Minnesota where there were existing Indian communities. The resources weren't sufficient to sustain an influx of Indians from Wisconsin, and they wanted to stay in their homelands. And there also wasn't a lot of impetus from citizens in Wisconsin who appreciated the services and trading opportunities that the Indians provided. So there was resistance to removal, and the government was trying to figure out how to compel removal. And they came up with the idea of transferring the annuity payments and telling the Wisconsin Ojibwe, if you want to receive your annuities, you've got to come to Sandy Lake. And the first year this was implemented was 1850. And there was a plan by the removal agent who was working under the territorial governor of Minnesota, Alexander Ramsey, to time the annuity payments so that they would draw the Wisconsin Ojibwe to Sandy Lake, keep them there late enough into late fall, early winter, so that the weather conditions would basically prevent them from going back to Wisconsin. So they brought people over, and then there were problems with the annuity goods weren't available. They didn't have enough food to subsist people that showed up. There was an outbreak of measles and dysentery, and people started dying. And the numbers are somewhat debated, but it was on the order of 150 men who had come to gather these annuities who died. And as people started dying, the Wisconsin Ojibwe resolved to go home regardless of the weather. And more people died on the way home, whether from disease or because of the conditions. So by the end of this experience, there was a loss of somewhere between 250 and 300 or 400 people. And that simply stiffened the resolve of the Wisconsin Ojibwe not to remove. And the government, the next year, the removal agent, his name was John Watrous, said that he was going to need the assistance of troops to force a removal. And when the Commissioner of Indian Affairs in Washington, D.C. learned about that, he put a halt to the entire removal operation because the government wasn't willing to commit troops and potentially engage in a kind of violent, forced removal effort, given that nobody seemed to really want removal. And there was a lot of protests coming not just from the Indians, but from non-Indians in Wisconsin and elsewhere. And that was really the end of the removal effort. It never really touched Mille Lacs, and it was unsuccessful as to Wisconsin. And then in 1854, there was a new treaty with the Ojibwe in Wisconsin and northern Minnesota. And in that treaty, the government established reservations on the territory that had been ceded in 1837 and 1842. So the whole idea of removing the Wisconsin Ojibwe kind of officially came to an end because they got reservations in their homelands where they could stay. Mille Lacs had not participated in the 1854 treaty for reasons that are not entirely clear. But the government didn't get everything it wanted in 1854. It wanted the Ojibwe to cede everything else in Minnesota, and the 1854 cession only was kind of the area proximate to Lake Superior. So they arranged another treaty in 1855, which was, the negotiations were held in Washington, D.C. And once again, there were efforts to exclude Mille Lacs, but Mille Lacs insisted on going. And in the 1855 treaty, it got a reservation at Mille Lacs on part of the land that had been ceded in 1837, but where they still retained hunting and fishing rights. Minnesota becomes a state in 1858, largely as a result of these treaties, which cleared Indian land title for much of the state. Indian people, including Mille Lacs, continue to exercise hunting and fishing rights. But over time, the state begins to adopt fish and game laws. They start right away, but they don't really enforce them till late in the 1800s. When they apply those laws to Indian people, they don't work very well because they're designed, a lot of them are designed, they're partly designed to protect fish and game, but they're also designed to accommodate sports fishermen and sports hunters, which is become a big movement in the United States by the late 1800s. So you have very short seasons for deer hunting, which works fine if you're a sports hunter, but not if you're a subsistence hunter, or not if you're hunting for ceremonial purposes. And similarly, the seasons for fishing and gear limitations are designed for sports fishermen, but not for subsistence fishermen, or not for people using fish as part of a culture and way of life. So Indian people start getting arrested. They protest that they have treaty rights. The federal government is inconsistent in their position about the treaty rights. Sometimes they say, yeah, there are these treaty rights. Other times they say, we don't know about them. Other times they say, whatever rights there were extinguished in the 1850 order, or by the 1855 treaty, or when Minnesota became a state, or for some other reason. And so there's this kind of standoff with Indian people insisting they have these rights, the state saying no, the federal government not being very supportive, that continues well into the 20th century. In the kind of mid to second half of the 20th century, as Indian people learn about some of the history, they start being more forceful in asserting their treaty rights. And there are some cases that work their way through state courts in Wisconsin and Michigan that recognize the existence of these rights. And then there's the beginning of federal court litigation in the upper Midwest, in Michigan, Wisconsin, and Minnesota, and out in the Pacific Northwest, where there are also treaties that reserve hunting and fishing rights. And one of the cases, the case that was most relevant for us, was the Voigt case in Wisconsin, which was initially brought by the Le Coudray Band against the Wisconsin Commissioner of Natural Resources, whose name was Lester Voigt. And in the federal district court, and that case involved rights under the 1837 and 1842 treaties. In the federal district court, one of the arguments Wisconsin made was that the 1837 rights and the 1842 rights were revoked by the 1850 executive order by President Taylor. The federal district court said, no, that's not correct, because those rights could only be revoked if there was some cause, if the Indians did something to harass settlers, or there was some reason for revoking them, and there wasn't any. And then, but he also said that the 1854 treaty in Wisconsin was intended to substitute reservations for off-reservation hunting and fishing rights. So he rejected the claims. Le Coudray appealed to the Seventh Circuit Court of Appeals, which reversed and said that the rights still exist, that there was nothing in the 1854 treaty that expressly revoked them, and in the absence of some express revocation of the rights, they remained in force. So after the Seventh Circuit's decision, my firm was pretty new as attorneys for the Mille Lacs Band. And one of the things we were asked to work on was the band's rights under the 1837 treaty. And so now that those rights have been upheld in Wisconsin, we wrote a letter to the Minnesota Commissioner of Natural Resources and said, we assume you will recognize the Mille Lacs Band's rights in Minnesota based on the decision in the Voigt case. And we'd like to sit down and talk about how to implement the treaty rights. I can't remember if the response came from the Minnesota Department of Natural Resources or the Attorney General's office, but their response is, well, that decision was wrong. It's in a different federal circuit. We're in the 8th Circuit here. We're not in the 7th Circuit, so it's not binding on us. And we don't think you have any rights, so if you want to pursue those rights, you'll have to file a lawsuit, which we did in 1990. And it turned out the case was a big deal in Minnesota. There were a group of 9 counties, led by Mille Lacs County, but other counties within the 1837 ceded territory in Minnesota that intervened in the case. There were a group of landowners that also around Lake Mille Lacs, and one resort owner and some other landowners who intervened, claiming that if the band had hunting and fishing rights, it would diminish their property values. After the case was filed, we had a series of kind of on-again, off-again negotiations with the state of Minnesota to see if we could settle the case. We had band members testifying at these hearings, including band elders who were treated with great hostility by some state legislators, and not, much more than a lack of respect. There was a certain tinge of racism to these hearings. There were people dressed up as Nazis parading around the legislative halls. There had been, as a lot of people know, a tremendous amount of violence when the Voight decision was made and implemented in Wisconsin, with people staging protests at boat landings, trying to swamp Ojibwe boats that were going out to fish. Slogans like "Spear a squaw, save a walleye" were popular in northern Wisconsin. It was kind of known at the time as the Deep North. And all of that kind of bled into Minnesota and the discussion of the settlement. The landowners and the counties and the opponents of the settlement, and Bud Grant was kind of the titular head of the opposition movement at the time, said that they didn't want any violence in Minnesota. They just wanted a court case to decide whether these rights existed or not. And so ultimately the legislature rejected the settlement. The band had its own referendum and it was approved by the band, but it was rejected by the state legislature, so we went back to court. And we had the court case that they wanted to decide whether these rights still exist or not. There was a trial in 1994. It was a 3-week trial beginning in June and ending on July 6th. The plaintiffs in the case were the Mille Lacs Band and 4 band members: Art Gabo, who was the chief executive at the time the case was filed, Colleen Benjamin, Walter Sutton, and Joseph Dunkley. And then at trial, 3 band members testified. By the time the trial was held, Art had passed away and Marge Anderson was the chief executive. Band members who testified were Herman Kaeg, Brenda Boyd, and Joe Dunkley, who talked about the importance of hunting and fishing to them and their families, ceremonial components of it, and also from a subsistence perspective and making ends meet when times were tough. Brenda Boyd talked about her father selling furs to pay hospital bills when her mother was sick. Herman Kaeg talked about spending 60 days in jail for violating Minnesota game and fish laws. Joe Dunkley had been cited for fishing with more than one line. And their testimony was pretty compelling testimony about the importance of hunting and fishing and what it meant to the band. By this time, the United States had joined the case in support of the band. That happened right at the kind of the deadline for parties to intervene in the case, but the United States finally agreed to support us and was a full party supporting our position. The 3 main issues in the case about whether the rights still existed was whether they were terminated by the 1850 executive order, whether they were terminated by the 1855 treaty, and whether they were terminated by Minnesota's becoming a state in 1858. So we presented a lot of historical context for each of those events and explained why we thought that none of them terminated the tribe's treaty rights. The state and the counties and landowners presented their contrary views. The case was tried in front of Judge Diana Murphy, who was the chief judge for the Minnesota District Court at the time, federal district court in Minnesota. And in August of 1994, she issued an opinion upholding the existence of the band's treaty rights and agreeing with almost all of the arguments that we had made in support of that. although the case wasn't really over because it had been divided into two phases. The first phase would decide whether the right still existed, and the second phase would be a kind of implementation phase where we decide how the rights would be regulated and whether there was any continuing room for state regulation. Normally you have to wait till the end of a case to take an appeal. They tried to do an immediate appeal, and ultimately that was unsuccessful. At that point, the 6 Wisconsin bands that were parties in the Voigt case intervened in our case, and so that they could assert the existence of their 1837 rights in Minnesota, and their primary interest was, I think, in fishing in Mille Lacs Lake. And at the same time, the Fond du Lac band had its own case. It was a little bit behind our case, and after Judge Murphy decided our case, I think it was Judge Erickson, had their case, and he said that, well, if the state just litigated these issues and lost them in the Mille Lacs case, so they can't relitigate them as to Fond du Lac. So he said Fond du Lac also had continuing rights under the 1837 treaty. And then we consolidated the two cases for the implementation. And that happened a little bit further down the road, but eventually the two cases were consolidated. And in this phase of the case, we developed a series of codes, tribal codes, to implement and regulate the right. In January of 1997, Judge Davis entered a final order and decree confirming the existence of the right and providing that as long as the bands adopted these various codes that we had developed, the state wouldn't be able to regulate the right. And the bands can modify the codes as long as, if they want to. This is an exercise of tribal sovereignty now to regulate the exercise of these rights. And the state can only object if they can show that there's some bona fide risk to conservation of a resource or some public health and safety threat that's not being addressed by the bands. Once the final decree was entered, then the state, the counties, and the landowners had their opportunity for an appeal. And at this point, we had I mentioned the three major issues from the original trial. Was really the executive order and the 1855 treaty. The issue about Minnesota statehood got interjected into the case a little bit later, but those were the three major issues that the state took up on appeal. The landowners appealed all sorts of things. They appealed, procedural rulings, resource implementation rulings, they had dozens of issues on appeal. But the state was really focused on those three major questions as to whether the right had been abrogated or not. And then we argued the appeal in front of a 3-judge panel, and they issued a decision pretty quickly affirming pretty much everything that had been done in the district court. There was one issue we had appealed in terms of access to private lands. We didn't prevail on that in the appeal, and then all of the arguments that the state and landowners and counties were raising were all rejected. So everything Judge Murphy did and everything Judge Davis did was affirmed. The next step was an appeal to the Supreme Court, which the state, the counties, and the landowners all filed what are known as petitions for writs of certiorari. There's no right to review in the Supreme Court. It's discretionary as to whether the court's going to take a case, and they don't hear most of the cases they're asked to take. So we got the petitions for certiorari, and we submitted responses, and waited, hoping the Supreme Court was going to deny them, as one would expect, because they deny most petitions for certiorari. And then one day we heard that they had granted the petition. They granted the state's petition, and then they just put the counties and landowners' petitions on hold pending resolution of the case based on the state's petition. And so then we got this whole team. So now we've got the Wisconsin lawyers, we've got the Supreme Court practitioner, we've got the folks at my firm, and we all went to work. We had 3 separate briefs on each of the main issues in the case. We had one brief on the removal order, we had one brief on the 1855 treaty, and we had one brief on the Minnesota admission to a state issue. And we divided those up among the lawyers, and worked on those, and then shared drafts and put those briefs together. We had another brief that a couple of the Wisconsin tribes submitted to tell the story of what happened in Wisconsin, because all of a sudden the Wisconsin treaty rights were at stake, were at risk, because if the court ruled against us on the 1837 treaty, the likely result would be to overturn the Voigt decision, at least on the 1837 treaty. And we wanted the court to understand what the Wisconsin tribes had gone through, and what had happened in Wisconsin once their rights were upheld, how they were implemented, how there wasn't a problem with the resources, and how they had to overcome all sorts of hostility. So the court had that background. So there was a brief on that issue. And then we had a friend of the court brief from some tribes in the Northwest on the issue about the admission to a state, because if Minnesota's admission to a state somehow revoked pre-statehood hunting and fishing rights, you could argue the same thing in Washington or Oregon or Idaho, because most of those treaties reserving hunting and fishing rights there were pre-statehood treaties. So there's a lot of work that went into that, into kind of identifying what briefs we wanted to submit and working on the briefs and getting them submitted. I thought the briefs came together pretty well. And then we started preparing for the oral argument in the Supreme Court, which was scheduled, I think, the last week in November of 1998. So now there's 8 tribes that are involved in the case: Wisconsin, the 6 Wisconsin bands, plus Mille Lacs and Fond du Lac. Organized a run from northern Wisconsin to Washington, D.C., which they would carry a ceremonial staff and other sacred objects, and it was basically a relay where the staff was never transported in a vehicle. It was transported by somebody holding it and running, and it was passed off from one person to another. There were Mille Lacs band members who participated in the run, as well as members of the Wisconsin tribes, and I think from Fond du Lac as well. And then when they arrived in Washington, D.C., they had worked out an arrangement with the National Indian Gaming Association, which had a building pretty close to the Supreme Court. And they started a ceremonial fire in the kind of backyard of this building, which they kept burning continuously from several days before the argument. I think people started arriving like 4 or 5 days before the argument, and then stayed until after the argument. And there were various ceremonies that took place in D.C. I forgot to mention one other issue we had was the U.S. was a party to the case, and so when you get to the Supreme Court, there are new lawyers involved for the U.S. Within the Justice Department, there's an office called the Office of the Solicitor General, and they handle Supreme Court litigation for the United States. And it's not the same lawyers that had been involved in the District Court or in the Eighth Circuit Court of Appeals, although they review briefs. They're much more engaged at the Supreme Court. And they wanted to take a different position about the 1850 executive order, because they were reluctant to argue that the order was invalid, which was what we had argued, that for a number of different reasons that order was not valid, and so it couldn't terminate the band's treaty rights. Normally, the Solicitor General's office, being part of the federal government, defends executive orders, and they didn't want to create a precedent that an order was invalid, so they came up with some new argument, which we weren't crazy about, but it had to do with whether the order ever became effective and whether it could be modified, and it was a little bit different position, and it was a little concerning for us, and we were kind of working with them, but they did what they decided to do in their brief. And then the argument would be divided between I was gonna argue for the bans, and then somebody from the Solicitor General's office would argue for the United States. And on the state side, there was a lawyer, a relatively young lawyer who had gotten involved during the Eighth Circuit proceedings, would argue and have most of the time, and then a lawyer for the landowners, a guy named Randy Thompson, would argue for them. So I also got back to DC several days before the argument, and participated in some of the ceremonies at the NIGA offices with folks that had come in from the run and otherwise. And there were a whole bunch of different ceremonies, and I was given things to have on me during the argument. They wanted to have this ceremonial staff in the courtroom, but the court said they couldn't bring it into the main courtroom, but they were able to bring it into the Supreme Court clerk's office, and they had it there, and there's a closed circuit feed, so people that were the custodians of the staff were able to watch the argument from there, and it was in the building. When the Supreme Court hears an Indian law case, there's an Indian bar in Washington D.C., so lawyers that practice Indian law, and they tend to all come to watch because these are important events. So there were a lot of Indian law attorneys in the audience. The state side went first, so first the landowner's attorney argued, and then the state argued, and then on our side, I went first, and then a young woman from the Solicitor General's office went after me, and she got very engaged in this case. I mean, she came out to Mille Lacs. We had a meeting of all the lawyers when we were working on the briefing out at Mille Lacs, and we had a kind of a sunrise ceremony on the lake, and there were prayers that were offered. There was an eagle that flew overhead, which we were told was a good omen, and she came out for that. And she was on the shores of Mille Lacs Lake in her high heels, and she looked like a very successful Washington D.C. lawyer. And she came to the ceremonies in D.C. also, which is how I got off on this tangent. So I did my argument, and then she did her argument, and she was handed this argument by the Solicitor General's office about the removal order, which most of the justices didn't quite understand, and so the argument ended kind of on a down note because it didn't seem like they were buying that argument, and it was hard to tell from my argument. I didn't really know. So we walk out, and a lot of times after an argument, there's people gather on the front steps of the Supreme Court, and there's kind of different groups. There was our group, and then there was the state and landowners in the county, and they were all high-fiving each other. They were sure they had won. They were all smiles, and couldn't have been happier. And we were a little more serious because I didn't really know how it was going to come out, and I had a hard time counting 5 votes, which is what we needed. I mean, I could kind of see 4 votes after the argument, but I was, just struggling to figure out where's that 5th vote going to come from. And from talking to some people, I heard the consensus from the Indian law bar in D.C. was that they weren't quite sure what the vote was going to be, but we were going to lose. It was just a question of whether it was going to be 6-3 or 7-2 or 8-1. But we didn't say anything. We went back. We did, there were some more ceremonies back at the NIGA building, and we didn't talk about, prospects one way or the other. We just kind of participated in ceremonies. And so all the Ojibwe people that were at the argument said, we're going to win this case, and they knew. I don't know how they knew, but they knew. So we went home, and we waited for a decision. And so the argument was late November, early December, and then we got the decision in March of 1999. And I found out because I got a call from a Minnesota NPR reporter. I was because of the time change, I was just getting up, and the phone rang, and I called, and it was a reporter who I knew, and she asked if I had any comment on the decision, and so I asked her to tell me what the decision was, because I didn't know. And so then she told me that the tribes had won, and I was just relieved. You know, it'd been such a long fight, and there was so much at stake that it's just relief. So that's kind of the story. I think it was after the Supreme Court had decided to take the case. There was another ceremony. This was before the sunrise ceremony, and there was a long speech in Ojibwe from one of the drum leaders, and you know, Don was able to kind of give me the gist of what he was saying, which what I remember now is like, when are they going to leave us alone? You know, we've been, you know, we had to go to we tried to settle, we had to go to the district court, we had to go to the Eighth Circuit. You know, why can't they just leave us alone? And it took one more round, and unfortunately, you know, a lot of the way I view this reservation boundary issue that we're dealing with now and the law enforcement situation, they still can't quite leave you guys alone.